The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of the Institute for Justice's Center for Judicial Engagement, as well as ace constitutional litigator Diana Simpson. This week on the show, jail booking photos, public funding of Planned Parenthood, crime scene photos in front of the parole board, and using Facebook without Facebook's permission. Evan, let's start things off in the Sixth Circuit.
Yeah, this is an important case involving the Freedom of Information Act. It's a federal statute that requires federal agencies to turn over public records upon request by press agencies and members of the public, even public interest law firms, concerning the operations of government. There are a number of exceptions to this general rule of disclosure, and the one relevant to this case involves law enforcement. Exemption 7C of FOIA permits agencies to refuse requests for records of information compiled for law enforcement purposes when they could reasonably be expected to constitute an unwarranted invasion of personal privacy. In 1996, the Sixth Circuit held that individuals do not have a privacy interest in their booking photos, the photos that are taken of them when they get arrested, and therefore FOIA's exception for law enforcement purposes doesn't allow agencies to refuse to turn over booking photos. The United States Marshals Service, after a couple of decisions in other circuits saying that, yes, individuals do have a privacy interest in those photos, has largely decided to simply stop turning over booking photos. And this case got going when the Detroit Free Press asked for photos of 4 officers who were arrested and who were booked, and they sought records from the USMS. The USMS refused to give it over, and the question is whether the USMS can rightfully claim a FOIA exception here. The courts in this case overturned its precedent and said, yes, there are privacy interests in booking photos. Federal agencies can choose to turn them over or not to turn them over on a case-or-case basis.
Quick point of order, the USMS is the United States Marshal Service. Diana, what was the court's reasoning behind this decision?
The court basically said that the internet has changed everything. And so back in the day when they were releasing booking photos, it would be on newspapers or the television, and then it would go away. And the only way for people to access it would be to go to the library and access the microfiche to look at the old newspapers. But today, as soon as it's released, people will then put it on the internet. And once it's on the internet, everyone can see it. And that these booking photos suggest guilt so strongly that people have a privacy interest in not being associated with this moment when they are very upset, and it's probably one of the worst moments of their lives. And all of a sudden, it's on the internet for anyone to see as soon as you Google the name of that person.
Right. So it's embarrassing, it's humiliating, and it's instantly everywhere. And the court says that based on subsequent developments in technology since 1996, we have come to the conclusion that there's a privacy interest where we previously didn't think there was. Now, the problem with that analysis, at least as the dissenting judge, Denny Boggs, points out, is that the fact that something is embarrassing or humiliating doesn't necessarily mean that it's private information. And when you're talking about a federal agency that's exercising coercive power over individuals, that's taking pictures of them, that's arresting them, and that is there's exercising coercive power, the idea that it might be able to choose or not to choose photos based on a nebulous set of privacy interests lends itself to a whole separate set of concerns about transparency and open government to which FOIA was designed and was committed.
So the Marshal Service is not categorically holding back jail booking photos. The question is whether they can do it when they want to, and in this case they did for the police.
Yes.
But what was frustrating was that the old decision back from 1996 wasn't even still a always release everything. It was that there were no privacy rights were implicated by releasing booking photos that were related to an ongoing criminal proceeding where the names of the defendants had already been divulged and where the defendants themselves had already appeared in open court. So that's still quite a bit away from just releasing every photo of every person. And now we're in this world where it's this amorphous case-by-case test that is, more often than not, probably going to end up with photos not being released.
Right, particularly when they involve individuals who are law enforcement officers who have been arrested and are accused of committing crimes. It lends itself to agencies taking advantage of the discretion that the courts give them. It's hard to square that with the function of FOIA, which is ultimately to make as much as possible the operations of government transparent. Yes, booking photos are humiliating and embarrassing. So is being charged with a crime, so is being on trial, so is being in open court, and yet we allow people access to the court. We make criminal records available. We do all sorts of things in order to ensure that the criminal justice system is operating in a way that's transparent, that people can understand, and they get a sense that what the government is doing is open to their view. And this, I think, cuts against that.
Diana, the dissenting judge, Judge Boggs, mentions that releasing these photos can actually protect suspects.
Yeah, so police abuse has been in the news recently, and one of the things that Judge Boggs is concerned about is that booking photos can help arrestees. It can help document the abuse of these folks. And the majority just kind of waves that away and says, well, the privacy interest belongs to the defendant, so of course he would want to go public if there's a picture documenting such abuse. But
Diana, how exactly can the photo document that abuse?
So if the booking photo, for instance, shows two black eyes and a split lip and those kinds of things, I think it's a fairly strong piece of evidence to show something happened to this arrestee. But, that arrestee might have that privacy interest and might be able to waive it, but he might not want to waive it, or he might not be willing to waive it, or he might have died at some point later and might not be able to. And so the idea that you can just paper over all of this, and particularly when in such situations the government is not going to want to release such photos, that's really concerning.
So is this an engaged decision, Evan?
I don't think it is. I think it's an example of judicial abdication, and that it lends itself to the government choosing when and how to release information that's relevant to the public's knowledge of whether the government is doing what it's supposed to be doing or whether it's abusing its authority.
Okay, let's move on to the next case, which comes out of the Ninth Circuit. Diana?
So this case is about social networking and a company called Power.com that used to exist and no longer does, but it would aggregate a user's social networking information. So they could show all of their social networks, combine all of this information into the Power.com website, and it would show all of the contacts they had across Twitter and Facebook and all of the other social networking websites. And the company existed and started this promotional campaign to attract more traffic to its website. And so it would work with different users and then utilize their access into Facebook to show an icon and send an email to that Facebook user's friends and show events and these sorts of things so that Facebook users would see it and want to join. And so Facebook became aware of this and sent a cease and desist order, and Power.com basically thumbed their nose at Facebook and, didn't agree to it and changed their IP address to get around Facebook's block and continued to do what they were doing. Facebook then sued. Power.com ended up shutting down, and the district court here decided that Power.com violated a slew of statutes, both federal and state, that basically prohibit users from accessing a website without authorization.
Evan, is this computer fraud and abuse?
That's the question, and the court came to the conclusion that yes, it is. It seems to stand for the proposition. This decision seems to stand for the proposition that if you tell people to not to visit your website, and they do it anyway, knowing that you disapprove, they're committing a federal crime. The reasoning of the decision is really sweepingly broad, and it seems to be in considerable tension with an en banc decision reached by the Ninth Circuit a few years ago involving very similar circumstances. So it's an important decision, and I think a very troubling one.
So Power.com did a little more than just visit Facebook's website without permission. They conducted business over it. Does that make a difference?
I don't think so in this context, because what's going on here is that you have a user effectively requesting that Power come into their space that they've cultivated on Facebook, invited them as their agent onto the website to make use of information that they have and they're now willing to share. The court is very focused on the fact that Facebook very clearly told Power don't do this, and Power not only refused to stop doing it, but engaged in very surreptitious means to continue to do it. But it's difficult to square this decision ultimately with a previous decision in which the Ninth Circuit held that it doesn't violate the Computer Fraud and Abuse Act to essentially ignore terms of service requirements for accessing a particular computer, that doesn't violate the CFAA. Whereas in this decision, it says that if you send a cease and desist letter that basically does the same thing as the terms and service requirements, that violates the CFAA.
But shouldn't Facebook have some rights to control who is on and who is using their material?
I think Facebook should have that right. But in this case, I think you have a situation where, the court is focused on this analogy. They come up with an example whereby you have a friend who has a safety deposit box at a bank, and it has their jewelry inside of it. The friend says, hey, you can come and you can borrow my jewelry, but you walk into the bank with a gun. Therefore, the bank can kick you out, even if your friend has allowed you access to the safe deposit box. But I think that what's really going on here is a situation, if you're going to extend that analogy, in which you directly go to the safe deposit box, you don't stride around the bank with a gun, you don't do anything inside the bank. The analogy doesn't work because I think that the physical space that a private business has is quite different from the public space that a website that's accessible by all members of the public has. So the same norms concerning trespass don't apply in the same way.
I'm just not sure that I agree. It seems to me that Facebook is spending a lot of effort and money in creating this space, hosting the servers, and they should be able to dictate who is on and who is not. I'm not sure that these particular statutes are the way to go about it, and I'm not sure I necessarily agree with how the Ninth Circuit has reasoned to its position, but it seems that they should be able to say, you can use it, you cannot. Period.
I think that's a different issue. I think that the question of whether there should be a civil action against Power for what it has done is a separate question of whether the statute actually authorizes somebody to be faced with criminal charges as a consequence of doing this. When the Ninth Circuit has, in a previous case, said that essentially, I think, functionally identical behavior doesn't give rise to a CFAA action.
So this is the principle behind Power.com is facing a criminal action. This is sort of a serious case.
Yes.
Okay.
And we're interpreting a federal law. So this is not just you've come onto my website without permission, I'm now filing a suit against you. This is you've committed a federal crime.
So the principal here is actually on the hook for almost $3 million, or for a little over $3 million in fines, and they're going to remand it down to the district court to figure out some other stuff. But because Power.com no longer exists, the Ninth Circuit found that the principal is responsible, and so he has to fork over all that cash.
Evan, let's move on to the next case, which comes out of the Eighth Circuit.
Yeah, so this case involves a woman who's convicted of really a horrific murder of her 3-year-old daughter and is sentenced to life in prison. Her sentence is later commuted such that she's now eligible for parole, and South Dakota has a state statute that provides for parole hearings. One of the members of the parole board was actually involved in her initial criminal sentencing, so he recused himself from what became a series of parole hearings in which she was consistently denied eligibility. And what she is claiming in this case is that this individual, despite recusing himself from her parole hearings, put 24 photographs of the horrific murder that she committed into her file, and thus biased the board against her ultimate decision the board's decision to deny her parole. And she claims that violates her rights to due process of law, which guarantees her an impartial adjudicator in a context where either her continued detention in prison or her freedom is at stake.
What did the Eighth Circuit say, Diana?
Well, the Eighth Circuit doesn't buy it because she's already had this impartial tribunal that she is entitled to, and there is no protected due process right to parole under the U.S. Constitution. And so basically the Eighth Circuit says, sorry, nothing you can do about it.
And so by the impartial adjudicator that Diana's referring to, I think you mean the trial that she had 20 years ago or so.
Right. And the difficulty that I have with some of the reasoning in the court's opinion is that if the parole decision were hypothetically made by members of the victim's family, or it was decided by coin toss, or some other procedure that really wasn't calculated to producing a reasonable evaluation of whether she ought to be released or ought to stay in prison, I think that we would all have a problem with that. In this case, the photos in question are certainly relevant to evaluating whether somebody is entitled to be released or not. I mean, it's a way of reminding you of just how heinous the crime is. So I think that in this particular context, what she is complaining about, what she has said biased the proceedings, isn't the kind of thing that should be excluded from a parole hearing, but the reasoning that says, well, just because you don't have a underlying liberty interest, therefore you're not entitled to some procedure that's not substantively reasonable and impartial is problematic. I think that the due process of law clause does give you guarantee that you not be subjected to arbitrary treatment by the government, and therefore I think that even if you don't have an underlying liberty interest, it's not necessarily the case that you don't have a due process of law claim.
Now, Evans' position conflicts with Matthews v. Eldridge, which is a long-standing Supreme Court decision that says what process is due in a particular situation. But that's Evans' position.
Yeah, well, I hold a lot of views that a lot of long-standing Supreme Court decisions are wrong. This is just one of the many of them.
And just to say it again, your position is that
my position is the due process of law clause does guarantee substantive, non-arbitrary treatment of individuals in the context of proceedings that could determine whether they stay in prison or whether they get released from prison. Insofar as we're talking about the state and we're talking about coercive power, that coercive power needs to be exercised in a way that is reasonable, that is context sensitive, and that is impartial.
Okay, let's move on to the final case. Diana.
Well, we're going to talk about abortion again. This case comes out of Utah. It's the Planned Parenthood Association of Utah. And if you'll recall, within the last year, there have been videos about Planned Parenthood and all the different affiliates throughout the country that purport to show the sale of fetal tissue and fetal body parts, which is illegal under federal law. And so after these videos came out, the governor of Utah came out and said, I think this is morally abhorrent, and I think we need to defund Planned Parenthood. Now, there's a whole bunch of different corporate entities involved here, but Planned Parenthood, the Planned Parenthood Association of Utah is an affiliate that is legally separate from Planned Parenthood Federation of America. And so the Planned Parenthood Association of Utah is an organization that provides a bunch of different benefits and a bunch of different programs within Utah, including free medication for certain sexually transmitted diseases, data gathering for STD prevention, and then different kinds of education, including abstinence and just other kinds of adolescent education. And so Governor Herbert came out with this directive that removed funding for Planned Parenthood, the Utah affiliate, even though the Utah affiliate wasn't associated with the videos and they don't use any of the government money that they receive for abortion. But Governor Herbert said that he wanted to remove this money, so he did. Planned Parenthood of Utah then sues the state of Utah, and this is up at the 10th Circuit, and the 10th Circuit says that that what the governor did was unconstitutional under the Unconstitutional Conditions Clause.
Evan, tell us about the 10th Circuit's reasoning.
So the 10th Circuit's reasoning is that Governor Herbert essentially used the reaction to the Planned Parenthood videos as a pretext to take funding away from organizations that were exercising constitutional rights in a way that he didn't agree with. The unconstitutional conditions doctrine is predicated on the idea that the government, insofar as it's dispersing funds, cannot use its power to disperse funds in a way that's predicated upon the relinquishment or in retaliation for the assertion of constitutional rights. The Supreme Court has said that the right to terminate a pregnancy is constitutionally protected, that the right to express one's views about the termination of a pregnancy is also protected. So insofar as Governor Herbert is alleged to have relinquished funds on the basis of the fact that Planned Parenthood of Utah is exercising its rights in ways that he doesn't agree with, he is acting unconstitutionally. And by looking at the sequence of events and also looking at Governor Herbert's specific admissions in the context of the preliminary injunction motion that Planned Parenthood of Utah is different than the national organization, that there's no fetal tissue-related issues involving this particular affiliate, in light of the fact that he has made a number of speeches indicating that he was responding to something that was unconnected with this particular organization, he was acting that there's a likelihood that a jury could find that this was an unconstitutional condition.
Diana, you have some thoughts about jurisprudence involving abortion.
Yeah, it seems to me that abortion jurisprudence is really a reflection of what a particular jurist thinks about the morality of abortion. So we have a dissent here, a concurrence and a dissent, who disagrees with the majority's decision on the unconstitutional conditions doctrine. And he reads into the facts his particular views. The majority reads into the facts their particular views. And it all really seems to me to boil down to, I think that whether I think abortion is right or whether I think abortion is wrong, I, as the judge, am going to find my conclusion and then reason backwards. And I think that's really all that jurisprudence has been since Roe v. Wade.
Evan, does that ring true for you?
It doesn't, because I think that you can be objective even in a context where you have a hotly contested underlying moral question. I think that the majority makes a compelling case that based on the sequence of events and the particular admissions made by the governor in this context, that a reasonable jury could conclude that, yes, there was an unconstitutional condition. I was unmoved by the dissent's argument that, well, if the governor was really antagonistic to abortion, he would have withdrawn funding, at some point during the 6 years that he was governor and that Planned Parenthood was continuing to operate. I think that it's very plausible, given the facts, that this provided an opportunity that he did not have to go after an organization that he did not like, and that the sequence of events could lead to led me to an inference that what was really going on was a piece of pretextual action.
And I think what's important here is the procedural posture. We're at a preliminary injunction hearing. We're not supposed to be deciding what a reasonable jury would do. Planned Parenthood affiliate has to show that they have a reasonable likelihood of success, which I think is a little more than that. And the dissent takes them to task for not providing a sufficient amount of evidence to win at the PI stage. And so it's a question of how many facts do they have, which is, I know, a common topic here at Short Circuit.
Mm-hmm. Well, the governor conceded in the context of that preliminary injunction motion that he didn't have any knowledge that this organization was doing anything illegal, that PPAU was separate from Planned Parenthood, that there wasn't even any fetal tissue program going on in his particular state, and yet nonetheless he took the actions that he did. We disagree on the facts. I think that you can objectively interpret them, and that at least in the context of a preliminary injunction motion, if you've got admissions from the governor that I didn't suspect that this organization was doing anything that was untoward, and yet I'm withdrawing funding from them, that's a problem.
Okay, that concludes the show. Thanks for listening, and don't be a stranger. Send thoughts and comments to shortcircuit@ij.org. And be sure to follow Evan and Diana on Twitter. Their handles are @EvanBurnick and @DianaK Simpson. And so until next time, this is John Ross from the Institute for Justice, recommending that you get engaged.